Court-annexed mediation is a form of alternative dispute resolution, whereby cases which are brought to court to litigation are referred to mediation for a possible settlement. That means court-annexed mediation is conducted while the cases are still pending in court. This is done by court order. The parties can ask the court to make an order for referral, or the court may consider the case appropriate for referral. Even if the parties do not ask, the court has the power to make a referral to mediation with or without the consent of the parties. For court-annexed mediation, there is no charge for the mediator or use of rooms. The cost of legal representation is the responsibility of the party. Now, you have already heard about the different stages process of mediation from yesterday, from Ms. Tanushree Rai, Ms. Priyanka Chakraborty, as well as from Mr. Kevin Brown in details. The same procedure is followed in court-annexed mediation. So I better skip over these topics to save the time. Now, it is said that more or less, the more laws, the less justice. It should be known to all that law is not only key to bring justice, or law does not always suffice to ensure justice. Where the law failed to ensure justice, then equity came to fill up the gap. Mediation as an alternative dispute resolution is an equitable process which ensures easy access to justice. What is the advantages of court-annexed mediation? The advantages of court-annexed mediation is that the judges, lawyers, litigants become participants therein, thereby giving to them a feeling that negotiated settlement is achieved by all the three actors in justice delivery system. When the judge refers a case for mediation, keeping overall supervision on the process, no one would feel that the system parts with the case. The judge would feel that he refers the case to a mediator within the system. The same lawyers who appear in a case retain their briefs and continue to represent their clients before the mediators within the same setup. The litigants feel that they are given an opportunity to play their own participatory role in the resolution of dispute. This will also give a larger public acceptance for the process. It is time bound by law and less expensive procedure, as already we have heard from Justice Iman Ali. I believe that mediation service under the control, guidance and supervision of the court would have more authenticity and smooth acceptance. It would ensure the feeling that mediation is complementary and non-competitive with the court system. The system will get a positive and willing support from the judges who will accept mediators as an integral part of the system. Court-annexed mediation will give a feeling that court's own interest in reducing its caseload to manageable level is furthered by mediation, and therefore reference to mediation will be a willing reference. I believe that this will establish a public-private partnership between the court and the community. The judiciary of Bangladesh is burdened with nearly 4 million cases. Today, the number is mounting day by day with the institution of fresh cases, so we can understand the importance of mediation in our judiciary. Now I will discuss the court-annexed mediation and the major laws of Bangladesh. There are a number of legislations in Bangladesh that have specially provided the provisions relating to ADR, particularly mediation and arbitration in civil matters. There are Code of Civil Procedure 1998, Muslim Family Laws Ordinance 1961, Family Courts Ordinance 1985, Arbitration Act 2001, the Authority in Adalat Ain 2003, Income Tax Ordinance 1984, Value Added Tax Act 1991, Customs Act 1969, Conciliation of Disputes Municipal Board Act 2004, Village Courts Act 2006, Labor Code 2006, EPZ Trade Union Industrial Relation Act 2004, Real Estate Development and Management Act 2010. Now, discussion on all the above statutes is not possible within this short period of time. I will highlight on the brief overview on the major laws in court and its mediation. Court and its mediation in family matters. Family Court Ordinance in 1985 was promulgated with a view to expedite the resolution of these cases to related to family affairs rapidly and effectively. Some family courts have been established by the ordinance. These courts have been following the mediation procedure in disposing the cases both before and even after closing of evidence. The family court is supposed to fix a date for pre-trial hearing within 30 days after the filing of written statement by the defendant. In the pre-trial hearing, the court generally ascertains the points at issue between the parties and attempt to effect a compromise or reconciliation. If that be possible between the parties, the court can take steps to compromise between the parties even after the closing of evidence and before pronouncing final judgment. Where the dispute is settled through compromise between the parties, the court execute the decree or give decision on the basis of the compromise. Now, court and its mediation in civil matters, this is very important. Justice Imanili has elaborately discussed this matter. So I'll briefly just give you some tips on this matter. The legislature incorporated mediation and arbitration provision in the code in civil procedure by way of amendments by inserting section 89A of the code in 2003. However, at that time it was discretionary power of the court. And now the law stands in 2012, which is mandatory. The mediation system is mandatory in civil proceeding. It was again amended in 2017 that made provision to refer dispute or disputes to the concerned legal aid officer. As stated in section 89 of Code of Civil Procedure, provided the provisions relating to mediation. The characteristics of mediation under the code is flexible, informal, non-binding, time-bound, confidential, non-adversarial, and consensual in nature. Yet the third party who works as mediator just facilitates the process. He can neither direct nor dictate how and in what terms the compromise will be reached. Rather, is between the parties who control over it. The court, as it stands now after Amendment 2012, it is mandatory. So every court have to send the case for mediation. There is no alternative. But the process is not mandatory. So it's already discussed by Justice Iman Ali. I better skip over that. After the written statement submitted before the court can initiate the proceeding or may refer the same to the concerned legal aid officer. And the parties themselves can choose the mediator, or the mediator from the panel is mentioned in section 89A, subsection 10 of the Code of Civil Procedure. His consultation with the president of the Bar Association, the district judge will prepare a panel. However, unfortunately, I don't have any information that any district bar has set up a panel like that. The section restricts time limit as well. The time frame for 60 days within that mediation process have to be concluded. The court may, however, on its own motion or the joint request preferred by the parties, extend time for another 30 days. So in total, 90 days and 7 days time for passing necessary order under Order 23, Rule 3 of the Code of Civil Procedure. The Section 89 of the CPC, or the Code of Civil Procedure, according to this section, the mediation process shall be confidential, communication made, evidence adduced, admission, statement or comment made and conversation held between the parties, their pleaders, and the mediator shall be deemed privileged and shall not be referred and admissible in evidence in any subsequent hearing of the same suit or any other proceeding. This is very important. This is the advantage. We have to pursue the clients and the other people that this is the benefit of mediation. The parties will always have the option to get back to the stage of formal judicial process from which the dispute has been sent to mediation. In case the court initiated mediation, the same court shall not hear and dispose of the suit if the court continues to be presided over the same judge. The parties will get back the entire amount of money, that is the court fees, if they reached on a settlement. And another advantage is that it will help to clear the backlog of cases that if settlement is reached between the parties and decree is final, then no revision, no appeal lies. So this is the most advantageous thing of mediation in our jurisdiction. I think so, that it will help to clear the backlog of cases because there is no appeal or revision. As mentioned earlier, the court also introduced mediation at the appellate stage back in 2006, but at that time it was not mandatory. In 2012, the same was mandatory again. Now every appeal deriving from original degree must be referred to mediation and comply with the same provisions as mentioned in section 89 of Code of Civil Procedure. Now I'll focus a little bit on authoring matter. The authoring Adat Ain is a special law. 2003 is a special law, everybody knows that. After the amendment in 2010, section 22 of the amendment authoring Ain incorporated the provisions of mediation almost in the same words and measures as is provided under section 89 of the code. Unlike the provisions of the code, authoring Ain created a scope for the authoring courts according to which courts may employ another attempt to order to effect compromise at the post-trial stage before passing a final judgment or order in accordance with the provisions of Chapter 4 of the Ain. The Ain takes one step ahead for the court in the sense that it provides for mediation provisions not at the appellate stage, but even at the revision and as well as executing stage of the authoring suit. Now, Village Code Act 2006, after formation of Village Code, the Village Code shall hear both the parties and shall take initiation for conciliation between the parties. If mediation is successful, the terms and conditions as the parties agreed upon will be incorporated in an agreement which is to be signed by both the parties and their nominated person. After that, Village Court shall pass the order or decree accordingly. Now move on to section 22 of Arbitration Act 2001. It's already said by Justice Iman Ali that mediation can be done at any stage of the proceedings, and if the parties resolve the dispute amicably, then the tribunal shall pass an agreed award. So we can understand that the importance of mediation from Arbitration Act as well. Now I'll discuss on criminal ADR in criminal litigation in Bangladesh. Actually, mediation has not yet widely introduced in criminal justice system. Although there is a section 345 of the Code of Criminal Procedure enacts provision for compromise in the compoundable offense. In fact, in the year of 1983, in a case of Mohammed Jainal and others, reported in 36 DLR AD, Appellate Division, page 240, former Chief Justice of Bangladesh, Justice Bodrul Haider Chaudhry, stated that they encourage a settlement of dispute either by panchayat or by arbitration or by a compromise, and if it is criminal offense, the offense can be compounded within the limit of section 345 of the Code of Criminal Procedure. Now, in another recent decision, in the case of Nur Muhammad versus State, reported in 29 BLT AD, page 29, our Honorable Justice Mr. Iman Ali, who disposing a 35-year-old criminal case, delivered a landmark judgment where he stressed the need to solve the problem through mediation in criminal matters for compoundable offenses. In his judgment, he suggested that the judges should consider the provision of Probation of Offenders Ordinance 1960, which is applicable both in lower court as well as in higher court. Now, I will briefly discuss the reasons behind decline of mediation in court and its mediation, briefly. From my point of view, I have identified the following causes that may be reasons for decline in the court and its mediation in Bangladesh. Non-cooperation of the lawyers. Justice Kurian Joseph has given some tips on how to involve the lawyers in a mediation. So we should actually follow this. That will help us. And most of the lawyers at district level are not cooperative at all in resolving dispute through mediation. I have noticed that in most of the cases, the engaged lawyers by the parties remain constantly absent when the court sets a date for mediation. The reason behind such non-cooperation on part of the lawyers, I think, primarily lies with the fear of losing their expected amount of income from the case if the case is disposed of through mediation at its very birth. So I suggest that positive impression should have to be increased among the lawyers regarding mediation by involving Bar Council and Bar Association as well. Also, yesterday, Mr. Abdul Matin Khosru mentioned to include mediation in LLB curriculum so that the law students should have encouraged about mediation from the beginning. I think it's a good idea and will be helpful to promote mediation. Now, ignorance of law is another reason. Many think that some of them are misguided and deceived by the engaged pleaders about the purposes and process of mediation. Absence of trained mediators or arbitrators. It is very common that we don't have, it is the real fact that we have few trained and mediators and arbitrators, and they are concentrated in our capital city, Dhaka. And they are quite expensive and mostly beyond the reach of the common litigants at district levels. And another is lack of mediation center. The problem that there's formal mediation center, we don't have formal mediation centers in district. Most of the cases, the parties sit either in the chamber or residence of the lawyer or in a restaurant in the district level, which is quite inappropriate for mediation. Change of mentality. Some people, they have preoccupied mentality that going for mediation would be a wastage of time. So we have to change this mentality, try to change the mentality by pursuing them. Further, there is no specific law like Arbitration Act 2001 for mediation. So I feel that the statutory body should be incorporated for formulating rules, planning, and monitoring mediation as well as for whole ADA system. Now, mediation under legal aid is very important. The provisions relating to ADA were incorporated into legal aid in 2013 by inserting Section 21A of the Act. In order to give effect to Section 21A2, the Legal Aid Act, the government has promulgated a set of rules in the name of Legal Aid Rules 2015. Rules 14 to 17 of Legal Aid Rules mention the ADA provisions in form of mediation, empowers the legal aid officer appointed under Section 21A1 to act as the mediator in cases of disputes that come to him either in the form of application for legal advice or by reference by any competent court or tribunal. Now, I have some suggestions for promoting a court and its mediation. There's confusion among the common people about the legal aid officer working as a mediator. The fact of his being a judicial officer should be circulated to the common people, and his designation as a judge should be encrypted into his nameplate properly to avoid the confusion among the common people. The legal aid officer needs to sit in a separate session, so the proper amenities should be ensured so that he can use the room for privacy between the parties, maintain the privacy between the parties. And for the safety and security of legal aid officer, as well as the people who come to legal aid office, must be ensured for better result. Usually, legal aid officer sits at district court. Many poor villagers who are willing for mediation but do not turn up considering the distance of the legal aid office Hence, in order to ensure increased participation from the farthest corner of the village, my suggestion is that legal aid officer may sit at Upajala on designated days by rotation. It is expected that legal aid office will be a hub for mediation, which will help to curb the backlog of cases in the courts. Public awareness need to be created, which Justice Imanali has actually discussed in details, that radio, TV channels, newspaper, social media like Facebook can be used to boost up mediation and to create the awareness among the people. Now, adequate training and mediator for the mediators and arbitrators is another thing we should focus on. It should be arranged from time to time. In this regard, Bangladesh International Mediation Society has already started training mediators and arbitrators with the help of domestic and internationally acclaimed trainers in a limited scale, and definitely doing a great job. BIMS should take steps to train the lawyers as well. Then they will be encouraged to be a professional mediator in addition to their legal practice. Now, there should be a reasonable fees for the lawyers who dealt with the mediation. Then they will be encouraged. A delay in disposal cases is become very common culture in our court system. It is also to kept in mind that mediation is not going to solve all the problems of formal judicial system as a panacea. But it is true that if properly used to its proper sense and spirit, it can significantly help to reduce the backlog of cases. Now, for practical reasons, arbitration is not working properly. So I believe mediation is the best solution to overcome the backlog of cases of our judiciary. Litigation should be the last resort. Mediation is currently seeing a success rate of 80% to 85% throughout the Western world. I believe you are the responsible judicial officers will try to promote mediation, and thereby we will be able to overcome the backlog of cases in our country. Also, it is necessary to ensure the independence of judiciary and transparency of prosecution, and most importantly, corruption should have to be removed from judiciary to overcome the backlog of cases. Resolving dispute outside the court is a good alternative option for laymen. In the words of former Chief Justice of Bangladesh, Honorable Justice Mustafa Kamal, said, ADR is a non-formal settlement of legal and judicial disputes as a means of disposing of cases quickly and inexpensively. It is not a panacea for all evils, but an alternative route to a speedier and less expensive mode of settlement of disputes. It is voluntary and cooperative way out of impasses. Now, as we are going to celebrate the 50 years of our independence, no one can deny Bangladesh has made tremendous progress in various social and economic indicators. The country saw steady increases in the GDP and per capita income indicators to give the impression that the country is on an upward trajectory. Therefore, we all have to come forward to overcome the problems of judiciary. Now, before I wrap up, I attempted to quote the words of John F. Kennedy during his maiden speech as the President of the United States on 20th January 1961, said that, quote, let us never negotiate out of fear, but let us never fear to negotiate. With this remark, I conclude my speech and express my sincere thanks to the guests from overseas for their valuable lectures, and heartfelt gratitude to the organizers of this training program, especially Mr. Goswami, who is trying his level best to promote mediation in Bangladesh. I hope you're enjoying the training and be safe during this pandemic. Once again, thank you all for listening to me with patience. I think I'm in time today.
Thank you very much, sir, for your resourceful and noteworthy presentation. If anybody have any question, you can ask to our Honorable Justice Ameshwar, sir. He is here to answer all your questions. I think Sarah had already cleared all the matter and confusion.
Thank you,
okay,
sir.
Okay, sir. You can ask. Imanali, sir.
Okay.
Yes, I just want to, it's not a question. I think it's a very good suggestion by Justice Ahmed Sohel that the legal aid officer may have, if you like, circuitry sessions in the upazilas on given dates, just to make the system more accessible. Obviously, any system which is more accessible is better than a system which is not accessible. But at the same time, of course, it has to be borne in mind that there has to be proper facilities available for the legal aid officer to run an office in the Upazila complex, wherever it may be. And that may be a problem because of the infrastructural facilities available. But otherwise, I believe it's a very good suggestion to make the system of mediation, particularly for the legal aid officers, to be more accessible, since it is the first instance where the litigant public can go for their redress of their problems, of their legal matters. And if that is available nearer home, then of course the people will enjoy it more and take benefit of it. Thank you.
Thank you, sir, for appreciating my suggestion.
আগেও স্যার আমি মহিদুজ্জামান জেলা দায়রা জজ পিরোজপুর থেকে বলছি স্যার। স্যার আমরা আমাদের লিগ্যাল এইড অফিসারকে অলরেডি এই ধরনেরই কার্যধারায় সংযুক্ত করছি এবং প্রত্যেক উপজেলায় যে আইন সমন্বয় হয়, যেখানে সভাপতিত্ব করেন উপজেলা নির্বাহী কর্মকর্তা এবং অন্যান্য জনপ্রতিনিধিরা থাকেন, সেখানে আমরা অলরেডি প্রোগ্রাম করে আমাদের লিগ্যাল এইড অফিসারকে পাঠাই আমাদের লিগ্যাল এইড সম্পর্কে ধারণা দেওয়ার জন্য, এবং একই সাথে সে মিডিয়েশনের বিষয়টাও সে সেখানে অলরেডি বলা শুরু করছে। এখন এটা আমরা আগে থেকে অলরেডি আমরা শুরু করছি, এটা আমাদের মাথায় এসেছে এবং আমরা অলরেডি শুরু করছি। ধন্যবাদ স্যার।
I think that is a very good initiative and it should be followed by others, because I personally do not see any legal bar in having this arrangement.
Thank you, sir.
আমার তরফ থেকে তাকে ওই দিন একটু আমার একটা গাড়ি প্রোভাইড করতে হয়, আমাদের যে মাইক্রোটা আছে সেটা আমরা তাকে প্রোভাইড করি, সে ওখানে গিয়ে তার একটা নির্দিষ্ট সেশনে লিগ্যাল এইডের কার্যক্রম একই সাথে তার যে এডিআর এর ক্ষমতা আছে বলে আসে। ধন্যবাদ স্যার।
Thank you very much, sir. At this stage, we have the issue of discussion on getting to yes. This is a very important part, and I humbly request. And I humbly request.
Yes, check.
Assalamualaikum, sir.
Sir,
I'd like to.
Sir, will I proceed?
Assalamualaikum, sir. Sir, I am Faizur Rahman, District Legal Aid Officer.
Mr. Faizur Rahman, I think perhaps since the introduction of the next speaker has already started, let us go on and you can make your comment after that. Thank you.
At this stage, we have the issue of discussion on getting to yes. This is a very.
Sir, I would put my questions later on, sir. Thank you, sir.
This is a very important part, and I humbly request Ms. Madeline Kimei, an international mediator, to present on this topic.
Thank you, Anindi. Thank you very much. Salam from Dar es Salaam. My name is Madeline Kimei. I am an advocate practicing here in Tanzania, and I am also a mediator accredited by the Chartered Institute of Arbitrators. I wish to first thank the judiciary of Bangladesh for allowing me to present here today on getting to yes, a very important skill for mediators. I recognize the presence of the Honorable Justice Imam Ali. Thank you. And I also recognize the presence of all other justices and legal practitioners attending this training on mediation. All protocols having been observed, I will proceed to project my presentation of getting to yes in mediation. I hope you can see the screen in front of you.
Yes, ma'am. Your screen is visible.
Thank you. And I'm sure you've gone through the definition of a mediation. And I'm sure you've explored in many ways how one could define mediation in the simplest form. And one of the definitions which I really, really appreciate is that of the Center of Dispute Resolution in the UK. This definition gives you all the elements that a mediation should have. The flexibility, that it's a flexible process, that there is a neutral person, the neutrality aspect, actively assisting the parties in working towards a negotiated agreement to a dispute on the parties. Now, I also always refer to a chap called Riskin, and Riskin takes it even more simpler and goes on to say that it's a process in which an impartial third party who lacks authority to impose a solution helps others resolve a dispute or plan of a transaction or in family-related disputes, in community-related disputes, all these aspects of a dispute that can be resolved by way of having that third person sort of assist the parties. Now, with that having been said, before I go on to now speaking about getting to yes, and as you saw on my first slide, I did say, or getting past no, there is a book that follows the getting to yes, and that's the getting to know by the same William Ori, which I feel that mediators should have both within their bookshelves. They're very helpful. Now, there are different approaches and different styles that mediators can have in undertaking the mediations. And there are different categories which we'll discuss, such as facilitative, evaluative, or there's one that is also referred to as directive approach, which I have not studied. I'm more prone to the facilitative and the evaluative approaches. Those first two are most common in mediation practice. Now, some mediators try to adhere to one style or another. Others have a blend of the two. Why am I speaking about these approaches? I'm speaking about these approaches because they play a pivotal part on how you approach your negotiation skills as a mediator, either when you're as a facilitative mediator or when you're an evaluative mediator. And overlapping approaches, as I say, the blended approaches, may be a function of the mediator style. So this is really up to the mediator, or maybe up to the case that is in front of the mediator. And they feel that it is appropriate to have an overlapping approach. That is the nature of the negotiations themselves and the parties presented before him. So my presentation, as I said earlier, focuses on the approaches in the context of mediations that are conducted between litigating parties engaged in negotiating primarily about money, a process known as either competitive or distributive bargaining. I am a commercial lawyer by practice, and so therefore I do mostly commercial or civil mediations. This process can be distinguished from interest-based negotiation, in which obtaining money may not be the primary objective, a process known as cooperative or integrative bargaining. So we'll explore all these concepts in this presentation. But one, before I proceed, and I had said this but before, I did want to play a small clip from a YouTube presentation that was done sometime back, 10 years ago, if I could say, by William O'Reilly himself. Now, if I could, with my let me see if my technology skills are good enough.
It reminds me of one of my favorite stories from the Middle East of a man who left to his 3 sons 17 camels. And to the first son, he left half the camels. To the second son, he left a third of the camels. And to the youngest son, he left a ninth of the camels. Well, 3 sons got into a negotiation. 17 doesn't divide by 2. It doesn't divide by 3. It doesn't divide by 9. Brotherly temper started to get strained. Finally, in desperation, they went and they consulted a wise old woman. The wise old woman thought about their problem for a long time. And finally, she came back and said, well, I don't know if I can help you, but at least if you want, you can have my camel. So then they had 18 camels. The first son took his half of 18 is 9. The second son took his third, a third of 18 is 6. The youngest son took his ninth, a ninth of 18 is 2. You get 17. They had 1 camel left over. They gave it back to the wise old woman. Now, if you think about that story for a moment, I think it resembles a lot of the difficult negotiations we get involved in. They start off like 17 camels, no way to resolve it. Somehow what we need to do is step back from those.
From what William is saying there is that we've all gone to experience this situation. And because my presentation is presented as a discussion, I wanted to hear from one or two of you as to what challenges do you face during either a quarter-next mediation, either as a counsel or as a judge wearing the hat of a neutral. Now, if it's possible, in a very good manner, we could raise maybe the hand and share your experience. Similarly to what William is talking about in not having on the table something that you could actually split equally and walk away on a win-win basis, because the whole gist about mediation is that there's that win-win solution. Now, is it always the case? Thank you. Is there anyone who wishes to make a point? No?
Okay,
yes,
thank you very much. Thank you very much for your nice deliberation and question. I would like to point out some important challenges which we usually face to mitigate the litigation, especially into the civil litigation. In the process of mediation, actually we know that we want to go to the utmost resort, that is win-win situation. But in our country, it is only win. The one party try to win, the plaintiff wants to win, as well as the defendant is also want to win. The role of mediator is to mediate or to facilitate the ideas of mediation, not to speak anything, not to give any guidelines, not to give any proper assurance that what the outcome is, what the outcome will be. So this is one of and every litigant people want that everything is okay, but the tree is mine. So the tendency of our people is not to mediate it. First one. Second one is that there is no legal pursuance actually. Sometimes we find that the Code of Civil Procedure has given the pursuance in Section 89 about the system of mediation, but in all laws, we have no system of mediation. But if we fail to mitigate the litigation, then what would be the consequences? It will go to the court ultimately. So it is not the solution. I have given my full effort to mitigate the litigation, but at the end of the day, the mitigation fails. So what would happen? The total system, the total effort that I have rendered to mitigate the litigation, that has goes in vain. And third one is that there is no specific pedal in each and every litigation that how we will mitigate the matter, what are the mitigation, what are the procedure actually, what are the system. By this paddle, we want to climb up 1, 2, 3, 4, 5, 6, 7 to the last resort. And all the criminal litigations are not actually compoundable. In our criminal system, we have found section 245 most probably, the compoundable sections, and some laws has given some reference about the compoundable system, but all the laws are not. So these are the challenges, and the time is a challenge definitely for the judges. They will have to handle lots of litigations, either civil and criminal and special laws. So the time is very constant, and they are facing a lots of scarcity of time into their offices. These are the challenges so far I have gauged, and thank you very much for asking me that question. Thank you.
Thank you. And I think the challenges do somehow attach to the skill set that we are trying to build. And from my attendance from yesterday and the little attendance that I did today, what I gather is that the system, the legal framework has been put in place. However, there is a sort of a gap in terms of what is in place and how to utilize and implement it. And so therefore, these trainings that we're currently undertaking are part of that implementation, the awareness, the creation of awareness of these rules. How do you get the people to invest in what is already been put in place by the legislature in Bangladesh to take advantage of mediation, a process that has been engraved or dates back centuries. And so the people buy-in is very important. And you make a very good point, Hassan, that the buy-in of the people would get mediation statistics to go up. Quarter next mediation statistics, as you say, are challenging because of the fact that the judge who mediates also plays a role as an adversary in the adversarial process as well. And of course, I'm sure the rules that are currently in place do not allow for the same judge who has played the role of the mediator in that case to also be the judge that adjudicates the matter. So there's that separation of obligation that usually is embedded in such a quarter-next system. The legal persuasion, I think it really drops down to the lawyers, the legal fraternity being able to embrace the current legislative framework with respect to the quarter next mediation. And if there's a panel, and I think I heard that there is a panel whereby the Chief Justice has put forward names who are mediators or approved mediators, that panel also needs to be used appropriately in the sense that panel also needs to get yearly CPDs in order for them to be able to be at the levels of trainings that you would wish them to be to handle such difficult cases coming out of the case dockets of the judiciary. Now, with regards to time, we'll speak about it in my slide, which are to come. Now, I take you back to a very good lawyer, and this slide captures it all. He says that a good settlement is better than a good lawsuit. This is Abraham Lincoln. And the fact that the vast majority of civil cases are settled proves that his admonition has been taken to heart. And in most systems where the implementation of that quarter-next system has been well done, we've seen this. And the widespread acceptance of mediation shows that it is a superior form of dispute resolution. Achieving a good settlement through mediation requires the lawyer in this case, to take a different approach than in the courtroom. we are sort of tuned from law school, from university, that we have this adversarial position-based approach to a dispute. And so when you do your case analysis and your client walks in, it usually is that, how do I win this case? As opposed to thinking outside the box. The use of litigation skills in mediation is not productive. Deal-making skills would serve the advocate far better. This is the presentation that I'm making. If you prepare carefully, adopt a candid attitude to the matter at hand, have patience, and are willing to compromise, you will find that mediation works well for you and clients. Now this is a perception that we need to change in the legal fraternities across the globe that are now developing the legal framework for mediation. Now, since my session is really on getting to yes and getting past no, I wanted to touch on what negotiation skills a mediator should have, or the negotiation skills that are actually being, put forward by William, which are very useful in getting to the yes. That is, the art of negotiation, as that slide says in front of you, is a qualified communication process. It may be defined as communication for the purpose of persuasion. And in your second point there, and if I noted it well, Hassan, was that the legal persuasion. But now let's talk about in the negotiation processes themselves. How do you persuade your clientele to consider what has been put forward for mediation? Now, or a process of communicating back and forth for the purpose of reaching a joint decision. We're moving away, William O'Roy says, we're moving away from positional bargaining which tends to result to unwise agreements, inefficiencies, and endangers relationships. You see, when you're in a positional bargaining, you're sort of stuck with a position. And negotiation is really a two-way street. Usually, you can't satisfy your interests unless you have satisfied that of your opponents. And in order to do that, it is important that you understand their interests as well. In a position-based bargaining, that won't happen. And so that frigidity of positional bargaining is what really William is talking about in his book, Getting to Yes. And of course, later on goes on to say, okay, what if you're dealing with difficult people? What if you're dealing with difficult people? What techniques do you need to get past the no? You see? So he goes on to say, getting past the no, you'd need to have control over your temper, for example, or your pressure, because you're under pressure. And how do you, as a mediator, have, or the parties involved, control that situation where the pressure is really on? Now, how do you do that? This is the book now, Getting to Know. These principles in this slide speak on, as I had already said, the positions. The positions are really the what's the negotiators say they want. They are really the solutions that have been proposed by the negotiators. And they're based upon the interests of the parties. Interests are usually not disclosed, the interests themselves. And so they will give you the positions, but the interests would not be disclosed in such a way. At least not in a competitive negotiation that we're speaking of, which is the the negotiation technique being proposed here. Now, the interests are the whys. And those are the reasons behind those positions. We'll also speak about the partner. And the partner is your best alternative to negotiated agreements. And I think we've all heard of this, the partner and the whatness. The partner represents the best result that a negotiator can get somewhere else if an agreement cannot be reached. And with that, I was reading an article and I came across the walkaway alternative, the interactive alternative, or the third party alternative. And when they speak of the walkaway alternative, they say that you find another supplier. So if this supplier is not going to provide your services the way you'd want it, you find another one. Then you have your interactive alternative, which is you strike or you go to war. And then you've got your third party alternative, which is the court system or litigation or arbitration. And so really when you look at your bottom lines, these are your bottom lines. And the zone of agreement is where the zone of agreement really represents the difference between the bottom lines of the parties. If there is no overlap between the bottom line of our fourth bullet point of the parties, then there's no possible agreement that could turn out in those circumstances. The principled negotiation that William R.I. and his friend propose is that this principled mediator should help the parties to separate themselves from the problem, he says. Then focus must be on the interests than on the positions, he says. Hence, the mediator should help the parties to shift the focus from their positions to their interests. So the mediator has a hard job doing this because, getting that rapport and building that momentum in the continent, sort of getting that balance is very difficult. Then the mediator is required to facilitate a generation of various options and selections of maybe options most acceptable to the parties. We are told in a mediation, when you're mediating, you can really explore solutions that are far more to the matter. Basically, there could be solutions other than those solutions that have been tabled by the parties, that the parties had not thought of. And so these are usually referred to as some sort of an improvement or some transformative way of transforming the parties to look into other options, a variety of options that they could select from that they otherwise wouldn't have reached if not by the assistance of that facilitator. When the perceptions of the parties differ in appropriate case or objective criteria like experts' opinions, scientific data or statistics, valuation reports, assessors' reports, audit reports can be relied on by the parties to examine the options and arrive at a settlement. And so these are the principles. And if you look at page 11 and 12 of Getting to Yes, these are the principles outlined by William and his friend on how principle-wise amicable problem solvers should adapt such a means of negotiating. The distributive bargaining, which is the competitive bargaining that we're talking about, is a customary and it's really traditional method of bargaining where the parties are dividing or allocating a fixed resource, such as property, maybe assets or money, company shares, marital goods or estates, and the likes. And in a distributive bargaining, the parties may not necessarily understand their own or the other party's interests. And therefore, often creative solutions for settlement could not be explored that well. It could not lead to a win or lose result or a compromise where neither party is particularly satisfied with the outcome. And so this slide here, as you can see, I will not read it word to word, but it does give you a picture of distributed bargaining, being that it is often referred to as a zero-sum game, where any gain by one party results in an equivalent loss by the other party. And these...
Ma'am, kindly make your discussion short.
Thank you. These could be positional bargaining, rights-based bargaining, interest-based bargaining, and the likes. And the negative consequences of distributive bargaining are those that are outlined there. Time-consuming, as highlighted by Hassan in his comment, and both parties take extreme positions, often resulting in an impasse. So the theory underlying the interest-based approach is advanced by the Roger Fisher, William R.I., and Bruce Patton in the Getting to Yes negotiating agreements. An interest-based approach focuses on the underlying needs or interests of the parties and encourages a broader range of solutions or resolutions to the dispute. And these three essential steps are put forward: identifying the interests of the parties, prioritizing the parties' interests, helping the parties develop terms of agreement, and then, of course, going on to integrative bargaining, which is really an extension of interest-based bargaining. And this is really where you're expanding the pie. And in expanding the pie, sometimes it's possible to brainstorm, increase resources to be bargained for. If the resources can't be or can be increased, then perhaps both sides can get what they want, or at least find sufficiently satisfying alternatives. For instance, a cell phone retailer may not decrease the price, but might be able to allow you to throw in maybe a free voicemail, or so on and so forth. Then you have the open information exchange as well. You get your log rolling and then your objective criteria. I like speaking about the Arab Bazaar. And, the Arab Bazaar here in Tanzania, in Dar es Salaam, we have a market called Kariakoo. And I think I've been to a similar market when I was in Dhaka, where you do your bargaining very quickly. And, if you're not careful, you might get outwitted by the seller. So this is what I call the Arab Bazaar, where you have wide choice and the bargaining characteristic is very important. So you have to have your goal. In distributive bargaining, it's like that. And integrative bargaining, it looks like this. And I'll share my slides because of time. I think you'll be able to see how integrative bargaining and distributive bargaining play well together. We spoke of the facilitative and evaluative and transformative evaluation types. Now, how do they peg with the negotiation skill that William and Roger Fisher are speaking about? All these are rights-based positional conflicts. In the evaluative process or in the facilitative process, you're either influencing assessment on rights-based positional conflicts, or in a facilitative process, you are facilitation involves little more than a mediator's sort of hands-off shuttling of the demands between the parties and going back and forth with the parties. It's a hands-off approach and not very similar to the evaluative, but it works to avoid war stories of any sort or impasse. Since I'm running out of time, I'll jump straight to something that I feel that is this is the facilitative approach, where you have your generating options, because there are different phases when you're doing your mediation, And when you do get to your generating options, you do take up certain skills which get you to the end solution. So there's a statement: the reason you negotiate is to produce something better than the results you can obtain without negotiating. What are those results is the question. What is that alternative? What is your partner, your best alternative to a negotiated agreement? That is the standard against which any proposed agreement should be measured. This is Roger Fisher and William Murray saying this. And so I'm posing this now to the parties and to the participants in trying to now trigger some sort of conversation with regards to developing a partner, because the partner does need to be developed, and the lawyers with their clients should be able to develop their partner throughout the process of mediation. And developing the partner really gives you the power. The better your partner, the more power you have in the negotiations. This is what Roger Fisher and William Murray say. And in discussing now, getting to yes, we need to understand how to also go to the balcony when the need is coming to light, that, the pressures are up and, the people are becoming more difficult. How do you then go to the balcony in terms of now cooling off and getting back to the table in order for those negotiations to go on smoothly? I'll just jump straight to my conclusion. And this is really the conclusion that I had in mind, is that you learn by practice, and you need to be flexible, and don't forget winning, because usually it doesn't happen that way. So the most fundamental aspect of mediation, or the mediator's objective, is to secure an attitude shift on the part of one or more of the parties. Without this, the parties are likely to remain in the same entrenched positions as they were they entered the conflict, creating little prospects or not at all prospects of settling the dispute. And so that's the fundamental aspect of these negotiations. I've outlined the biography, and so you could reach out to these novels or these books and links to the TED Talk that I had played before. So thank you very much. I think my time is up, and I pass it on back to the moderator. Thank you.
Thank you, ma'am, for such a remarkable presentation. Now I'd like to invite Mr. Veeraraghavan Invavijayan, an international mediator, to discuss on the model law.
Thank you. Thank you for the moderator to give a sweet introduction. Am I audible?
Yes, sir.
Thank you. I'm very happy to follow Madeline's version about getting to yes. Good afternoon to honorable judges. Good afternoon to Justice Imam Ali, sir. I think it's a third occasion to see him, and it's really an admiring opportunity. For the past two occasions, whenever I used to get his comments, it's really interesting from a judicial person, that to the pro-ADR aspect. Thanks, sir. Thanks for the compliments, what I heard from the last two sessions. This session, which is on the model law, which predominantly deals with what's happening globally and why we need to have a universal acceptance of the mediation. The task is given to me. I'm going to share for another half an hour about the model law. When it comes to mediation, the model law, the present scenario is considered to be the Singapore Convention on Mediation. For arbitration, we have, I think many of you would accept that even in Bangladesh, the Arbitration Act is an outcome of the United Nations Commission for International Trade Law, Model Law for International Arbitration, 1985. The same when it comes to conciliation or mediation, we did have on 1980 UNCITRAL model law for conciliation, or they call it UNCITRAL conciliation rules. These are very common terminology used for ADR mechanisms when it comes to the model law. A new development, the new development in 2019, the mid of the year, in the month of July, August, there was a new development wherein a convention called UNISA, United Nations, the Convention for International Settlement Agreements, came into force, and more than 40 odd countries signed that particular convention. India was one signatory, and many other developed countries also were the signatories in the initial signature ceremony. And now it is going on adding. Now I think it's crossed 53. Many countries have started adopting this model law, or the commonly called as the Singapore Convention on Mediation. Having said that, I have to share that why people are starting to rush to mediation and what is the interest about this model law on mediation. As the earlier speakers were highlighting about the mediation, the significance of mediation, the possibilities of referring matter to mediation, and or the advantages what we have when a party chooses a mediation. All these were quite shared with the earlier speaker, but still the categories, when you're looking on the categories of mediation, this particular model law facilitates a lot. The major types of mediation, which is already discussed by many of the speakers, and the former, the judge also was highlighting about the court annexed mediation, is a paramount mediation, what in our subcontinent we are very popular and familiar. That is also recognized by this convention, the model law. There's a court annexed mediation, then the parties are facilitating the mediation by agreement based, as well as there are some institutional mediation. All these are very prominent categories of mediation, but for our legal culture, the best suitable was the court annexed mediation and the agreement based mediation, and the institutional mediation we have to wait and see how it is going to develop, subject to all what the training all of you are going to get. To begin with, the court annexed mediation is predominantly facilitated by the Bangladesh Code of Civil Procedure, Section 89A. It is very common in most of the civil procedure codes in the Commonwealth countries. They have brought in this court annexed mediation concept. That court annexed mediation concept is facilitating not only mediation, it's also facilitating conciliation, arbitration, and other locally recognized ADR mechanisms. When we take on the commercial disputes, which one is suitable and which model law can we just adopt? A simple answer is that for commercial disputes, it is always better to go with agreement-based mediation. As most of you are sitting judges and justices, it is very common that 89A can be comfortably invoked, and the pending suit can be referred to mediation. But when it comes to agreement-based mediation, paramount importance or significance is given to an existence of a mediation clause. This particular model law gives an opportunity, great opportunity for the judiciary as well as the disputing parties to go to mediation. The clause, an agreement, a mediation agreement or an agreement to mediate is most important, and that too, it gives an option for existing dispute as well as future disputes. A common understanding is that in the contract or in an agreement, if they have a mediation clause, it's going to deal with the future dispute. Now, coming to the aspect of existing disputes, this model law is facilitating that even after a dispute has arisen, the countries who are adopting this model law has a legislation that it can also be mediated, subject to a submission mediation clause. Or The court also is facilitating in many jurisdictions that if a party file a suit and pending suit, instead of referring the matter to mediation under 89A, the courts also are deferring the hearing, asking the parties to enter into an arrangement that is mediated existing disputes to be referred to mediation, a submission mediation clause. If a submission mediation clause is there, even at that stage, the parties can opt for that particular process, that is the mediation, which is agreement-based mediation. This is the future if any country is going to adopt the model law. Having said that, if it is going to be the future of countries who are going to adopt this model law, what the existing signatories of this convention or the model law, they are doing about this particular model law. Countries like Singapore, Belarus, Iran have already ratified, and they have just enacted a mediation law. This model law is going to facilitate a mediation law or an act, a mediation act in our jurisdiction. Bangladesh is yet to sign, but anyway, there are various judicial personality. The government also is the verge of planning to sign this particular convention. And once this convention is going to be signed and ratified by the states, and particularly Bangladesh, then Bangladesh also would have a law, a mediation law to deal with the mediation procedures, the process, and the enforcement aspect of that particular outcome. What we are seeing, what we are presently seeing is a conciliation. I think many of you would accept that we are into a lot of conciliation, particularly in this subcontinent. And what has been taught about conciliation by the model law, that is the act, the rules, Ancestral Conciliation Rules 1980, speaks about various aspects, that starting from the definition of conciliation till how the conciliated settlement agreement is enforced. Looking into the definition of conciliation, it says that a conciliation means a process whereby parties request a third person to assist them in their attempt to reach an amicable settlement of the dispute arising out of or relating to a contractual or other legal relationship. This definition about conciliation, which is very prominently suggested by the model law relating to conciliation, is also similar to mediation. But the only thing under section 89A of CPC suggesting to conciliation or mediation, and a similar grounds of section 89 of the Indian Code of Civil Procedure, is all facilitating this conciliation, which is considered to be evaluative and not facilitative. Many of the speakers would have highlighted that the mediation, the main, the ideology of mediation is to facilitate a settlement, not to evaluate. But conciliation goes further, and it goes on evaluating the disputes between the parties and ultimately a solution. It might be a settlement. The outcome of a conciliation or a mediation is similar. But the only thing is that an outcome of a conciliation has a valuable tooth. That tooth, the existing tooth, is that it can be enforced as a consent award. If you have a look on the arbitration legislation in your country, particularly the provision for settlement, there is an option for the arbitrator to try to mediate that particular process. That disputes can be taken to mediation in arbitration itself. That was suggested by the ancestral model law for arbitration. We can see mediation in arbitration, and the outcome would be recorded as an award on agreed terms, that is a consent award. The same status is also available for a conciliated settlement agreement. That is the tooth, the effective tooth of conciliation, what we are already using in our existing system, wherein under section 89A we are referring. This is based on the ancestral conciliation rules of 1980. And Because of that only, we invariably depend much on this conciliation, and the conciliation process would be so comfortable for the parties. We can go with one conciliator, whether it is referred by the courts or whether the parties on the agreement basis itself, they are referring the matter to a conciliator. It all depends on the basic characteristics of free opportunity given to the parties. And finally, the outcome alone differs from the mediation. The good thing is that the conciliator also doesn't initially sign the settlement, but when a conciliated settlement agreement is likely to be treated as a consent award, then that conciliator also endorses that particular settlement. If an endorsement is there, fortunately, the conciliated settlement agreement would have an enforcement nature. It will be enforced similar to an award which is derived out of settlement. That advantage we had, particularly in the subcontinent, wherever we adopted the unsettled conciliation rules 1980. Now we are deviating from this. The Western concept of conciliation, which is facilitative, is now being adopted in our system. It's a welcome thing. A mediated settlement agreement is much more recognized universally than a conciliated settlement agreement. Exception is when until and unless it is considered to be an award on agreed terms. Why we are moving from this conciliation and mediation, particularly looking into this model law? What is the advantage given under this model law? And what is the significance of this model law, that is the Singapore Convention on Mediation? Certain points are there. I'll just quickly go through those points. The first point is that it is an essential dispute resolving instrument facilitating dispute resolution of international trade, and ultimately it is promoting mediation. Many would be seeing into this concept of international mediation, and being this model law which is dealing with international settlement agreement. The recent Qatar issue, there was a blockade, economic blockade, free movement of people blockade. Various measures were taken by the Emirate countries along with the Kingdom of Saudi Arabia. Recently, it got resolved by a mediation, which is considered to be an international mediation, a public international mediation facilitated by Kuwait as well as US. This is one example of public. Likewise, there are a lot of commercial disputes to be mediated. There are various family disputes to be mediated. There are various trade-related disputes to be mediated. There are various joint venture disputes to be mediated. Every aspect of the coming under the jurisprudence of the definition of dispute now can be easily mediated. That is fortunately facilitated. There are some riders, no doubt, like any model law or convention, we do have certain riders, but still the riders are very minimal. The ratio of positive implementation of this mediation process is quite high when a country is going to adopt this model law. That is a first significant point. Second point, the binding nature and enforceability in accordance with a simplified and a streamlined procedure. This is a great change from the unsettled conciliation rules 1980. The Singapore Convention, that is a UNISA Convention 2019, is giving an enforcement character for the final outcome of the particular process, the mediation process. A binding and enforceable, not only that, a simplified and streamlined procedure. All combination of start with a simple procedure. Literally, it is considered to be informal procedure. There is no need to have a structured procedure. Informal procedure laid down by the mediator, or the parties can agree, okay, this is how we can proceed. That flexibility is there, and it is made simple. And finally, the outcome, the mediated settlement agreement, is considered to be binding, and it is going to be enforced. That is facilitated by this model law. This is going to be a real competitor to an arbitration. I think most of you, the judges, the honorable judges would accept that nowadays arbitrations become expensive. The arbitration also is considered to be an adversarial process, and arbitration also is lacking the tooth of effective enforcement because of certain setting aside process or an appeal process in our arbitration legislation. Those appeal process would also get it delayed to get the final outcome to be enforced. All these complication is now by this model law is going to be removed. Simplified, streamlined procedure with binding nature and enforceability is the second interesting point about this particular model law. Thirdly, the businesses seeking enforcement of such a mediated settlement agreement, not only domestically, they can also implement this across borders. And it can do so by applying directly to the courts. That is very important. It is not that there is an impediment by the court of the enforcing state which is going to object or which presumes that it doesn't have a jurisdiction to entertain and enforce such a mediated settlement agreement. If the state which has signed and ratified this particular model law or convention, then the legislation, the mediation legislation is going to facilitate enforcement, not only a domestic dispute, an international dispute also. As of now, this is facilitating international settlement agreement, but when we are going to have a mediation act or a law in our country, in India, it is in the pipeline. In India, already 3 interesting legislation has adopted mediation before even signing this particular convention. Namely, the Commercial Courts Act in India in 2015. They have included mediation as an effective process, and they are given an opportunity how to enforce it. That means that domestic commercial disputes can be dealt by it. Then we had this quite early itself, but it got the rules and regulations later. That is the Companies Act 2013. The grand old 1956 and the British era companies legislation got repealed in India in 2013. There also they brought in mediation with enforcing capability. And recently in 2019, the same similar months of the signing ceremony of this particular convention, Singapore Convention, we had this Consumer Protection Amendment Act that also facilitated mediation. And all these combined together, we had as a common law system, our judiciary also recommended or had a great observation asking the legislature to consider enacting Mediation Act. We need to have a Mediation Act. If that Mediation Act on lines with this particular model law, the convention, then we can also effectively deal with domestic as well as cross-border disputes with mediation with a simplified and a cost-effective manner. The next point, obviously, that cost, it minimizes time as well as legal cost, which happen to be the crucial, important factor, which is totally disturbing the litigants. The litigants are not preferring to go to the courts because of various the procedural delay laid down by our procedure law. Even though it is working out effectively, still we have our the impediment, which is not specific to any stakeholders, but unfortunately our procedures make it stretched, and we have this docket explosion, many cases pending in our courts. That's why the parties are preferring to ADR, and that ADR also facilitated by the court. Now, if it has been facilitated to mediation with this convention to be considered, or the model law to be considered, then the time and cost would be realized reasonably realized by the litigants. Further down the line, some significant aspect is that, and very interestingly is that, the certainty we can get a final outcome, and not only that, that final outcome is going to be recognized, not enforcement, okay, fine, recognized by another country court, which also going to adopt that particular model law. All these significant aspect is going to bring mediation as a very effective tool if a country is going to adopt this particular convention or the model law. Anyway, I think Bangladesh also is in the pipeline, is in the discussion to sign and ratify, so that a mediation law is going to facilitate all. One thing here, many would have an aspiration that what type of disputes can be taken and what this particular model law is suggesting. The model law has certain reservation. The model law specifically says that it doesn't apply to certain consumer disputes, family disputes, inheritance, employment disputes, all these. Many people would have a question that, oh, why consumer disputes in India, a consumer legislation or regulation has been amended, mediation has been brought in. In family disputes, many countries it has been brought in. Inheritance also. Here, this model law, since being a model law, it is giving some recommendation that these are quite sensitive issues which has to be dealt only by special legislations or personal laws of the respective countries. If specific countries have specific personal laws which is going to deal with certain disputes, then those disputes would not be disturbed by adopting this particular model law. Example of a few like consumer, family, inheritance, or employment. It can vary from jurisdiction to jurisdiction, but this is a very common phenomenon provided by the model law. And it also goes further, and it is not going to disturb the existing court-annexed mediation. If a court is approving a process under section 89A and referring it to mediation, that mediation is followed based on the existing rules and regulations of the respective high courts or the particular jurisdiction, and that this convention or model law would not be applicable. Further, settlement agreements which is enforceable as judgment need not be disturbed by this convention. And most interestingly, a settlement agreement which is enforceable as an arbitral award doesn't comes under the purview of this model law. That is the arbitration, in the arbitration process, which is called R-MED, start arbitration. In arbitration, if the arbitrator tries to mediate and that mediation gets, it's very reasonably, it's get a final conclusion and is a success, then that success would be recorded as a award, and that award is considered to be an award on agreed terms, and that award on agreed terms cannot be considered by this particular convention. That is totally different. That is an arbitral award. We are mediating. In mediation, the outcome is just a mediated settlement agreement, and it is not a recent settlement award. That cannot be considered. These are some exceptions which has been given when it comes to applicability of this particular model law. Okay, adding on certain aspects when it comes to model law applicability for mediation in any jurisdiction is that certain conditions are given for recognition by this convention. What are those? A settlement agreement must have been concluded after the convention has been entered into force. It is prospective, not retrospective. Further, the dispute must be international in nature until and unless a national legislation on mediation is enacted. Till a national legislation is enacted and the country has ratified this particular model law or convention, till that time, only international disputes can be dealt, not the domestic. Once the mediation law comes, then the domestic disputes also can be taken to mediation, and automatically this convention applies for that domestic dispute also. Thirdly, parties must supply a number of documents to the competent authority of the state in which they wish to enforce to take place. Where they wanted to enforce, obviously, lot of instrument has to be produced. These instrument, we have to wait and see what this model law convention is going to bring out. As of now, we don't have a clarity on this number of what type of documents is expected. And finally, very, very important is that the convention also includes the possibility that a party may provide any other evidence acceptable to the competent authority to prove validity of the settlement agreement. This settlement agreement, when it comes to enforcement, until and unless a national law is established or created for mediation, would be a process based on multiple documents as well as certain evidence which has to be in acceptable form to the competent authority. Many jurisdictions, they are facing a lot of issues looking into this particular convention and the conditions for recognition of this convention. But we have to wait and see to what extent it is going to work out. I think I have only a reasonable time, 5 to 10 minutes. I'll just quickly go through what are the other key features of this particular model law or the convention. As I just earlier mentioned, this particular convention includes all type of disputes. That's the word they are using. It sets out the types of mediation to which this particular model law applies, and the Singapore Convention is obviously limited to commercial disputes which are international in nature until and unless a national legislation is created. It's a very common word they are used. Like our arbitration legislation, this mediation model law also suggests that anything that comes within the purview of the definition commercial can be taken to mediation. That also has been simply adopted here in this model law also. But they have given a clarity that all these disputes are excluded, as earlier I mentioned about the family, inheritance, employment, personal, the consumer, all these, the exceptions are given under the major salient features of this particular convention as inclusions and exclusions. Further looking into the term mediation, half an hour before I was just trying to share with us what is conciliation under the model law for conciliation. But when it comes to the model law of mediation, Article 2, Subarticle 3 provides the meaning for the term definition, and it goes like this. Parties to reach amicable settlement of their dispute with the assistance of a third person or persons who are called as a mediator, lacking the authority to impose a solution upon the parties. That's the word they are used, very cautious words. Mediation is an attempt by parties to reach an amicable settlement. It is not dispute resolution, it is amicable settlement of their dispute with the assistance of a third person or persons who are called as mediator or mediators who lack the authority to impose a solution upon the parties. There is a great change from conciliation to mediation. In mediation, it is clearly given that the third person who's assisting to reach for an amicable settlement lacks the authority to impose a solution upon the parties. They are just a mediator. A commonly used word mediator is perfectly adopted, and what the Black Law Dictionary was stating, the same words has been adopted in Article 2, Subarticle 3 of this convention. The very interesting distinguishing first time we have got a model law which has categorically given a definition for this term mediation. Now we can identify the distinguishing character of conciliation and mediation. Now it is purely facilitative. It is not going to impose any solution. There is no evaluation of the dispute. Just that person is assisting. The neutral person is assisting an amicable settlement. And we further look on, there are some formalities. If you look on the subsequent article, which says that the requirements that the settlement agreement must be signed by the parties. There must be evidence that settlement agreement resulted from mediation. All these are quite some formalities which has been suggested by the Singapore Convention. Most interestingly, one thing this model law says, what is new to mediation is that there is a provision wherein there is a ground for refusing relief under outcome of this mediation is possible. The grounds for refusing relief by a mediated settlement agreement, which has been listed in subsequent articles, are really exhaustive. But to make it very simple, certain things like if a party who is party to the settlement agreement is under some incapacity, if the relief given is contrary to the public policy of the place of mediation, if the subject matter of the dispute is incapable of settlement by mediation in the host country. Further, if the settlement agreement itself is null and void, inoperative or incapable of being performed, if the settlement agreement is not binding or is not final according to the terms, it is not final, it's like a tentative settlement agreement. And if you add on, there are various aspects given for ground for refusing a relief under mediated settlement in this particular process. And very, very vulnerable issues that if the settlement agreement is not clear or comprehensible, then that settlement agreement also cannot be accepted for enforcement. It is very clear that if you are going to adopt a model law, any country, if it's going to adopt the model law and model law, mediated legislation is going to be adopted in your country, then you will also have a provision wherein the outcome of that mediated settlement has to be reasonably tested. Nothing wrong in it. The model law also recommends that the mediated settlement agreement is not final, still it has an option. It is having an option if the country ratifies and a law is enacted, then that law would have a provision for refusing to grant relief, which has been an outcome of that mediated settlement agreement. This might be a trouble creator, but this we cannot avoid because a mediator, as rightly Madeline was mentioning about an arbitrator taking the role of a mediator, once again, whether he can act as an arbitrator or a mediator, whether he or she can act as an arbitrator for the same dispute. All these issues, which is called R-Med-R as well as Med-R, all these theories of conducting two types of ADR mechanisms is also tested, likely to be tested when we are going to have a mediation legislation. Fortunately, some countries, example Singapore has smartly reserved their rights when it comes to grounds for refusing relief under the mediation. We have to wait and see how it is going to work out. The important point, what I wanted to highlight is that this particular model law, if is going to be adopted in any jurisdiction, particularly where the jurisdiction like Bangladesh or India or Pakistan or any other country which is predominantly the common legal system, those legal system or the jurisdiction would be benefited, and the mediation, which we think that it is going to be really a successful process, will also reach our jurisdiction. Thank you. thank you for giving the opportunity to share about certain points about this model law and convention.
Thank you very much, sir, for your wonderful presentation on model law. It is the task if you have any query. Yes, sir. Imanali, sir.
Yes. I just want to compliment Mr. Inva Vijayan on his full portrayal of the model law. But I just want to also make it clear that the model law is for international mediation, and what we have already in our law books are matters relating to our national mediation. Although I do agree that our national law on mediation is scattered all over the place. The mediation provisions exist in all different laws that we have heard this morning from myself as well as Justice Ahmed Suhail. So perhaps it would be a good idea to incorporate a fully comprehensive mediation law, having one part to deal with national mediation and the other part to deal with international mediation, as we do have specific law provisions in our Arbitration Act relating to international arbitration matters. The other thing that I would like to highlight is that it has been said that the Companies Act in India has already mediation provisions. Unfortunately, I've just been looking through our Companies Act, which is of the year 1994. So it's before we introduced mediation in our legal system for the court mediation. So that's probably why it is not there. But then since then, we have had several amendments to the law, and still the mediation aspect is not incorporated in our company law, which I believe would be a good idea, because even now we have many cases in the Supreme Court which are being referred to mediation by our courts. So it could be there in the law, although I do see there is a provision in the Companies Act with regard to arbitration with reference to the Arbitration Act. So mediation is obviously absent, and it could be, I think, introduced. I would say it should be introduced, because that is, as we have said in the last 2 days, is a better way of resolving disputes. Thank you.
Thank you. Thank you, sir. Thanks for the compliment.
Thank you, sir, for such a nice question and answer session. Now it is a time of accessor speech by Ms. Jamila A. Ali, Senior Counsel, Supreme Court of Guyana and Caribbean Court of Justice, Certified Mediator, Faculty Member of Bangladesh International Mediation Society, President of Mediation Services International.
Good afternoon to everyone from Guyana. Early morning here. Honorable Justice Muhammad Imam Ali, Mr. S.N. Gosami, Chair of BIMS, judges, mediator, lawyers, and other participants, all protocols observed. I have listened to all the presentations, and I must say that the training session for the judges have been comprehensive, informative, and full of content and substance. Consisted of local as well as international trainers. We've heard from India and Tanzania, all of high profile, highly qualified, and very experienced in their respective fields. All the presenters extolled the virtues and benefits of mediation, and their presentations consisted of oral and written presentations on slides and even video clips. The various presentations complemented and supplemented other presentations. I have to start by saying that the feedback was really interactive, with judges asking several interesting questions, showing that they were engaged in listening to the mediation process. The training started yesterday with Ms. Anindita Hassan Hasname, and apologize if I'm not pronouncing it correctly, who set the tone of this discussion with her soft, soothing voice, which is an important ingredient for the mediation process. An opening speech was given by Mr. Abdul Matin Kashu, a Member of Parliament, who started the discussion with the reason why mediation is needed. It was indispensable, and it is needed to promote justice and to alleviate the sufferings of the people due to the backlog of cases. And he made a recommendation that it be included in the LLB syllabus, which was later made by Justice Sohail. The Honorable Justice Imam Ali, as the most senior judge, led the training and advocated very passionately that mediation was desperately needed in Bangladesh, and told us about the backlog of 4 million cases, which could only be reduced by mediation. He referred to arbitration, which had lost ground and was not effective as mediation was. He promoted mediation and all its attractions, and that the parties control the process. Justice Imam Ali started today's session by outlining the sources of mediation, which included the 2012 amendment of the Section 89A of the Code of Civil Procedure, which made mediation mandatory, but gave the good news that it was reinforced by a recent circular from the Judicial Reforms Committee of the Supreme Court to all judges, outlining a detailed mandate, which was still in draft, directing judges to observe the mandatory provisions at trial and appellate level. It also created a panel, makes provision for creating a panel for mediators. There was also reference to the other sources, sections 89C and D, the Arbitration Act, the labor laws, and of course, the legal aid officer. Justice Ahmad Sohail also made reference to the laws and the history of the laws. Justice Imam Ali went into a very detailed presentation today about the duty of judges and their role to tell people, to tell the parties about mediation, that it was speedy, time-bound, it was completed in a maximum of 90 days or just over 3 months. It's less expensive, of course, because you can get legal aid and the parties can go to the legal aid officer, which was free. An agreement leads to finality. There is no appeal. There is no execution. And as an incentive, there's a refund of court fees. And this would lead to peace. The process was confidential, informal, and the parties were in control. In other words, mediation as an alternative dispute resolution mechanism was better than arbitration. And the goal was to publicize mediation. The Honorable Geeta Mittal, a former Chief Justice in India, also gave a very enthralling presentation on the role of judges in promoting mediation. She started with the ADR process from Islamic origin. However, the judge cautioned that ADR must not be used to avoid litigation for a party who has no case and prevent a plaintiff from getting the remedy that they're entitled to. She emphasized confidentiality, which leads to credibility and accessibility. And judges are mandated to make reference, and this was also highlighted by His Honor Justice Imam Ali. The judge's duty is not just to refer the matter to mediation and no more when the matter comes before you. Just don't say this matter is referred to mediation, I'm mandated by a circular or by the law. You must go do further, and you must give the parties a knowledge and complete understanding of mediation, the pros and the cons, and that the judges play a seminal role enabling the parties' confidence, and to place the mediation on an equal pedestal as litigation. Mediation was a give and take process. However, it should not be used as a delay to the trial, and in this regard, a schedule of time should be set by the judges. The judges were a strong mediation tool to advance the mediation process and maintain which would maintain future relationships. She cautioned that settlements must be workable, voluntary, and not illegal. And good judges can exercise great tact in persuading the parties to settle. She cited cases from India on mediation. The role of the judiciary in encouraging mediation was also emphasized by retired Justice Kurian Joseph, who focused on the passion for justice and expanded on what Justice Mittal said. He summed it up well by saying that the role of the judges goes beyond adjudicating a winner or a loser. The role of the judges goes beyond adjudicating. They must be an educator, a conciliator, a peacemaker, and a negotiator. And they must create mediation-friendly courts and try to win the cooperation of the lawyers, the clerks, and the court staff. Mr. S.N. Goswami gave a detailed history of sources of mediation in Bangladesh. This was very informative. It was delivered in his native language, and mediation ethics are the basis for mediation proceedings, and mediation process will open the doors on new life. Ms. Tanushi Roy presented on mediation in a globalized world. She started with the historical origin of mediation from the panchayats who resolved their own domestic disputes, made reference to the Quran and the Bible. She, like the previous speakers, outlined the benefits of mediations to the backlog and the adversarial system currently prevailing, and outlined and repeated and emphasized that mediation is an assisted negotiation to assist the parties to make better decisions. And the role of the mediator was to guide parties to resolve their differences, save time and money. She made reference to advancement of mediation in other countries, including France, Russia, Australia, Iceland, Italy, Israel, and Hong Kong, and emphasized that mediators must take account of cross cultures. An overview of the process of mediation or the stages of mediation was given by her and was also expanded by Priyanka Chakraborty as well as Ms. Dr. Kevin Brown today. The stages of mediations were referred to with the opening statement, the opening introduction, the joint session, the caucus, the closing statement, the agreement. But Mr. Kevin Brown added a pre-mediation session and expanded on the previous speakers on the role of mediation and refer to the mediator's code of conduct and the difference between interests and positions, which were also spoken to by the other parties. Ms. Priyanka Chakraborty kept the discussion lively with an interesting video clip and made the point that the mediators don't judge, and while the process is mandatory in Bangladesh, and the advantage of this is to increase awareness and be informative. She did an interesting illustration of a conflict of three sides: people, process, and problem, and spoke about the different types of mediation, which were evaluative, facilitative, and transformative, which was also mentioned by Madeleine Kimai today. They were very, the court annexed mediation in Bangladesh was presented by the Honorable Justice Ahmad Sohail, and he focused on it enabling a partnership with the court and made some useful suggestions for promoting mediation, including involving the Bar Association, making legal aid more accessible, and pay lawyers a fee, which might be a bit controversial. Madeleine Kimai from Tanzania did an interesting presentation on getting to yes and referred to getting past no, and the approaches to the conduct of mediation, and spoke about the art of negotiation and principles dealing with difficult persons, shifting from positions to interests, bargaining, and generally a theme that has been focused by Justice Imam Ali, which is changing attitudes, there being an attitude shift. We last just heard about the model law, which deals with international mediation. Over the 2 days in sum, I would say that the objectives of BIMS were achieved to promote mediation in Bangladesh, to familiarize judges on mediation, to change attitudes, and that mediation is the best alternative to litigation, to reduce the huge backlog of cases in the administration of justice, and that this alternative would have the ripple effect of easing the suffering of the peoples of Bangladesh. And I believe the approach of targeting judges was the correct approach, because they are the most important tool in this process in getting the parties and the lawyers on board and to persuade them to embrace the process of mediation. The history and the origin, and judges were given a refresher on the local laws as well as international sources. The process was outlined. We had the roles and the qualities of the mediator, the types of mediation, the benefits of mediation, the mediator's code of conduct. The duty and the role of judges was emphasized by several of the speakers. They were given the mandate, as I've said previously, to refer the matters, to use their great tact and skill and the powers that the judges possess, to educate and give the parties a complete understanding of how the process works, why they should embrace mediation in a more meaningful way, so as to make it more accessible to the public at large. Of course, to sum it up, to say it saves time, money, a speedier process, it's less expensive, legal aid is available and free, reduces backlog, the parties control the process, they make their own decisions, they preserve relationships, they will get a refund of court fees. In all, I would say that the presentations were all well researched, articulated and given in a clear manner, and real examples were given. In all, it is a win-win situation that should be embraced by the peoples of Bangladesh, with the judiciary heading it. And I must say that Justice Imam Ali is indeed one of the most passionate advocate of mediation in Bangladesh. I wish to thank Justice Imam Ali as well as Mr. S.N. Gosami, the chair of Bangladesh International Mediation Society, for giving me this opportunity to make this short presentation. I believe that BIMS did an excellent job with this training. And I wish to, before I take my leave, to close with two small suggestions. Perhaps more time can be given to the participants' interaction, and perhaps online mediation might also assist with the reduction of the backlog, having regard to the COVID pandemic now affecting the entire, well, most of the world. So in addition to physical mediations being done, perhaps the use of online mediations can be considered or supplement the physical mediations that are going on. And that is going to be a lot more cases can be done on a daily basis. I thank you very much.
Thank you, ma'am, for your valuable speech. At this moment, I'd like to invite Mr. Khandokar Mohammad Rafiq Hasnain, learned advocate, accredited mediator, and regional director of BIMS Bangladesh chapter, to convey thanks.
Thank you, Anindita. BIMS কর্তৃক আয়োজিত তৃতীয় বিচারকদের জন্য মিডিয়েশন বিষয়ক প্রশিক্ষণ কোর্সের মাননীয় প্রধান প্রশিক্ষক, বাংলাদেশের সুপ্রিম কোর্টের সর্বশ্রেষ্ঠ আইনজীবী, আমাদের সকলের প্রিয় ইমান আলী স্যার, যিনি অতি সম্প্রতি আন্তর্জাতিক মিডিয়েশন অ্যাওয়ার্ড অর্জন করেছেন। দীর্ঘদিন থেকে মিডিয়েশন বিষয়ে অবদান রাখছেন, কাজ করে চলেছেন। এই মিডিয়েশনটাকে বাংলাদেশে বাস্তবায়নের জন্য দিনরাত স্বপ্ন দেখছেন। তিনি 2 দিন ধরে এই মিডিয়েশন কোর্সের প্রধান প্রশিক্ষক হিসেবে কাজ করছেন, সার্বক্ষণিক আমাদের সঙ্গে ছিলেন। সেই জন্য বিমসের পক্ষ থেকে তাকে অনেক অনেক ধন্যবাদ, কৃতজ্ঞতা এবং অভিনন্দন। এটা মার্চ মাস, স্বাধীনতার মাস, স্বাধীনতার সুবর্ণ জয়ন্তী চলছে জাতির জনক বঙ্গবন্ধু শেখ মুজিবুর রহমানের জন্ম শতবর্ষ, মুজিব বর্ষ। আমাদের অনেকগুলো স্বপ্ন, স্বাধীনতার অনেক স্বপ্ন, বঙ্গবন্ধুর স্বপ্ন মিলেমিশে একাকার হয়ে গেছে। বাংলাদেশকে সোনার বাংলা তৈরি করতে হবে, এই বাংলাদেশকে মানুষের মতো মানুষ তৈরি করতে হবে, মানুষের মতো মানুষ বানাতে হবে রবীন্দ্রনাথের সোনার বাংলা, নজরুলের রূপসী বাংলা, আর জীবনানন্দের বাংলাদেশ। তাহলে আমরা এগিয়ে যাব। স্বাধীনতার 50 বছরে বঙ্গবন্ধু কন্যা, জাতির পিতার কন্যা আজকে বাংলাদেশে হাল ধরেছেন। তার নেতৃত্বে আমরা এগিয়ে চলেছি। আমরা উন্নয়নশীল দেশ থেকে উন্নত দেশে পরিণত হয়েছি। আমাদের একটা ডেল্টা পরিকল্পনা আছে, আমরা ভিশন 2041-এর পরিকল্পনা আছে। আমরা আশা করি তার নেতৃত্বে, জাতির জনকের কন্যার নেতৃত্বে, বাংলাদেশের যিনি বর্তমান প্রধানমন্ত্রী জননেত্রী শেখ হাসিনার নেতৃত্বে আমাদের ভিশন 2041-এ আমরা পৌঁছে যাব অতি শীঘ্রই। এবং সেই জন্যই আমাদের এই বিচার ব্যবস্থাটাকে, এই বিচারের অবস্থাটাকে, বিচার প্রার্থীদের জন্য একটি সুন্দর পরিবেশে নিয়ে যেতে হবে স্বাধীনতা স্বপ্ন বাস্তবায়নের জন্য। সেই জন্য মামলা জট কমাতে হবে। আর মামলা জট কমানোর জন্য হ্যাঁ, আমি শুনতে পাচ্ছেন? হ্যালো,
হ্যাঁ শোনা যাচ্ছে।
থ্যাংক ইউ। মামলা জট কমানোর জন্য এই মিডিয়েশনটাই একমাত্র পথ হিসেবে বেছে নিলে এই বিচার ব্যবস্থা কাঙ্ক্ষিত জায়গায় পৌঁছতে পারবে। দুষ্টের দমন এবং শিষ্টের পালনে আমরা চলে যাব। আজকের এই অনুষ্ঠানে, ধন্যবাদ দেবার অনুষ্ঠানে আমি অভিনন্দন জানাই, আমি ধন্যবাদ জানাই জনাব আব্দুল মতিন খসরু এমপিকে, যিনি বাংলাদেশের সাবেক সফল আইনমন্ত্রী এবং অতি সম্প্রতি এই গতকাল যিনি বাংলাদেশ সুপ্রিম কোর্টের সভাপতি হিসেবে নির্বাচিত হয়েছেন, তিনি বাংলাদেশ জাতীয় সংসদের আইন, বিচার এবং সংসদ বিষয়ক মন্ত্রণালয়ের স্ট্যান্ডিং কমিটির চেয়ারম্যান। তার সময়ে এই বাংলাদেশে তিনি যখন আইনমন্ত্রী ছিলেন, তখন তার সময়ে বাংলাদেশে লিগ্যাল এইড আইনের মতো একটি যুগান্তকারী আইন প্রণীত হয়েছিল। তিনি কথা দিয়েছেন তিনি জাতীয় সংসদে আমাদের কথা বলবেন, মিডিয়েশনের কথা বলবেন, অতি সম্প্রতি যত দ্রুত সম্ভব মিডিয়েশন আইন যাতে জাতীয় সংসদে পাশ করে বাস্তবায়ন করা যায় সেই জন্য ভূমিকা রাখবেন। এবং সেই জন্যই আব্দুল মতিন খসরু বাংলাদেশ সুপ্রিম কোর্টের বার অ্যাসোসিয়েশনের সভাপতি নির্বাচিত হওয়ায় বাংলাদেশ ইন্টারন্যাশনাল মিডিয়েশন সোসাইটির পক্ষ থেকে তাকে অভিনন্দন জানাই, লাল গোলাপ শুভেচ্ছা জানাই। এই 2 দিন ব্যাপী প্রশিক্ষণ কোর্সের পেছনে যার অবদান সবচেয়ে বেশি, তিনি হলেন আমাদের বিমসের চেয়ারম্যান জনাব এস.এন. গোস্বামী স্যার। তিনি সর্বসময় আমার মনে হয় বিমস ছাড়া আর কিছু ভাবেন না, মিডিয়েশন ছাড়া কিছু ভাবেন না। বাংলাদেশের মিডিয়েশনের চ্যাপ্টারটাকে তিনি অনেক দূর এগিয়ে নিয়ে গেছেন। বিমস তার নেতৃত্বে পৃথিবীর 29টা দেশে কাজ করছে এই মিডিয়েশন বিষয়ে। তার নেতৃত্বে আমরা এই মিডিয়েশন যে কর্মশালা করছি, প্রশিক্ষণ করছি এবং আমরা কাঙ্ক্ষিত জায়গায় পৌঁছে যাব আশা করি। গতকাল অনেক রিসোর্স পার্সন তার বক্তব্য রেখেছেন, তাদের অভিজ্ঞতা, তাদের দক্ষতা, তাদের পারদর্শিতা আমাদেরকে মুগ্ধ করেছে। বিশেষ করে ম্যাডাম প্রিয়ঙ্কা এবং ম্যাডাম তরুশ্রী, তারা চমৎকার ভাবে, স্বভাবসুলভ ভাবে আমাদের মাঝে এই মিডিয়েশন বিষয়ে প্রশিক্ষণ দিয়েছেন এবং আমরা মোহিত হয়েছি। আমি ধন্যবাদ জানাই মিস্টার মহিদুজ্জামান, পিরোজপুরের জেলা জজ, এই প্রশিক্ষণের কোঅর্ডিনেটর হিসেবে কাজ করেছেন। তার আন্তরিকতা আমাদেরকে মুগ্ধ করেছে। আমরা যখনই তার সঙ্গে যোগাযোগ করেছি, তিনি সবসময় হাসি খুশি ভাবে আমাদেরকে গ্রহণ করেছেন, আমাদেরকে রিসিভ করেছেন। তার আন্তরিকতার জন্য তাকে ধন্যবাদ জানাই এবং আরো ধন্যবাদ জানাই পিরোজপুরের ল্যান্ড সার্ভে ট্রাইব্যুনালের বিজ্ঞ বিচারককে। অনেক জ্ঞানগর্ভ বক্তব্য রেখেছেন জাস্টিস কোরিয়ান জোসেফ স্যার। তিনি সুপ্রিম কোর্টের সাবেক বিচারপতি। তিনি তার জীবনের অভিজ্ঞতা, দক্ষতা, পারদর্শিতা দিয়ে আমাদেরকে পথ দেখিয়েছেন। আমরা আশা করি তার প্রেরণা, তার বক্তব্য আমাদের জন্য পাথেয় হবে। ইনভাবি জিয়ার মডেল ল নিয়ে বক্তব্য রেখেছেন, আর সবচেয়ে আমাদের বক্তব্য রেখেছেন আমাদের অত্যন্ত কাছের মানুষ বিচারপতি আহমেদ সোহেল স্যার। আহমেদ সোহেল স্যারের মাধ্যমে আমরা সবাই মিলে অত্যন্ত সমৃদ্ধ হয়েছি। আজকে এই অনুষ্ঠানে ধন্যবাদ জানাই যারা প্রশিক্ষণার্থী হিসেবে অংশগ্রহণ করেছেন, বিশেষ করে বরিশাল বিভাগের সব জেলা জজ মহোদয়গণ অত্যন্ত আন্তরিকতা নিয়ে সকলেই আমাদের এই মিডিয়েশন প্রশিক্ষণে অংশগ্রহণ করেছেন বলে বিমসের পক্ষ থেকে অত্যন্ত আন্তরিকতার সাথে কৃতজ্ঞতা প্রকাশ করছি। শুধু তাই নয়, সমস্ত জেলা জজ মহোদয়গণ তাদের নিজ নিজ জেলার লিগ্যাল এইড অফিসার সহ অন্যান্য জুডিশিয়াল অফিসারকে দিয়ে আমাদের সঙ্গে সংযুক্ত ছিলেন বিগত 2 দিন। এবং আমাদের এই সংযুক্তির ফলে আমাদের যে অভিজ্ঞতা অর্জন হয়েছে, আমাদের যে পারস্পরিক মত বিনিময় হয়েছে, এটা মিডিয়েশন জগৎ অত্যন্ত কাজে লাগবে এবং আশা করি খুব তাড়াতাড়ি এই বরিশাল বিভাগের সবগুলো জেলাতেই মিডিয়েশন সেন্টার প্রস্তুত হবে। আমরা বরিশাল বিভাগকে একটা মডেল বিভাগ হিসেবে দেখতে চাই। নিশ্চয়ই আমাদের প্রত্যাশা পূরণ হবে। আমি ধন্যবাদ জানাই আমাদের সঙ্গে কাজ করেছেন যারা পর্দার অন্তরালে ছিলেন, বিশেষ করে অ্যাডভোকেট পঙ্কজ কুন্ডু, যিনি আমার বাংলাদেশ চ্যাপ্টারের প্রেসিডেন্ট, অ্যাডভোকেট হুমায়ুন কবির শিকদার আমার বাংলাদেশ চ্যাপ্টারের সেক্রেটারি, অ্যাডভোকেট আলমগীর, অ্যাডভোকেট আফরোজা, অ্যাডভোকেট সব আমাদের সঙ্গে কাজ করেছেন। বিশেষ করে তন্ময় রহমান, আমাদের ট্রেনিং অ্যাসোসিয়েট, তন্ময় সবসময় যোগাযোগ করেছেন আমার সঙ্গে, বরিশাল বিভাগের কোঅর্ডিনেটর সাহেবের সঙ্গে। এবং হোটেল পূর্বাণী আমাদেরকে এই প্রশিক্ষণের জন্য জায়গা করে দিয়েছেন এবং যারা আমাদেরকে টেকনিক্যাল সুবিধা দিয়েছেন তাদের সকলকে ধন্যবাদ জানাই। ধন্যবাদ যারা আমাদের বাইরে, দৃশ্যের বাইরে যারা কাজ করেছেন, পরিশ্রম করেছেন, তাদের এই নিশ্চয় পরিশ্রমটা সফল হয়েছে। এবং আগামী দিনে এই মিডিয়েশনের মাধ্যমে বাংলাদেশের যদি মামলা জট আমরা কমাতে পারি, নিশ্চয়ই আমরা
প্রাইম মিনিস্টার অফিস
হ্যাঁ, এবং সবচেয়ে বেশি সহযোগিতা করেছেন পর্দার অন্তরালে থেকে আমাদের প্রধানমন্ত্রীর কার্যালয়ের কর্মকর্তাবৃন্দ। তাদের আন্তরিকতা, তাদের সাহায্য, তাদের সহযোগিতা এবং সর্বশেষ গভর্নমেন্ট অর্ডার হবার ক্ষেত্রে তাদের যে আন্তরিকতা আমাদের মুগ্ধ করেছে। এবং আমরা খুব দেরিতে হলেও গভর্নমেন্ট অর্ডারটা পেয়েছি, জিওটা হয়েছে। যাই হোক, প্রাইম মিনিস্টার প্রধানমন্ত্রীর কার্যালয় থেকে আমাদেরকে এই সাহায্য সহযোগিতা না করলে এত সুন্দর একটি সফল অনুষ্ঠান আমরা করতে পারতাম না। এই জন্য এই বিমসের পক্ষ থেকে, বাংলাদেশ ইন্টারন্যাশনাল মিডিয়েশন সোসাইটির পক্ষ থেকে মাননীয় প্রধানমন্ত্রী এবং মাননীয় প্রধানমন্ত্রীর দপ্তরের সকল কর্মকর্তা কর্মচারীদেরকে আমরা শুভেচ্ছা জানাই, অভিনন্দন জানাই, ধন্যবাদ জানাই। আর আজকে নিশ্চয় আব্দুল মতিন খসরু স্যার আমাদের সঙ্গে যুক্ত হবেন এবং ওই অনুষ্ঠানটা এরপরে ইমানুয়েল স্যার বক্তব্য রাখবেন এবং আগামী এই বিমসের উত্তরোত্তর শুভকামনা করে, উত্তরোত্তর কল্যাণ কামনা করে, উত্তরোত্তর সফলতা কামনা করে আমি আমার বক্তব্য শেষ করছি। জয় বাংলা, জয় বঙ্গবন্ধু, বাংলাদেশ দীর্ঘজীবী হোক।
Thank you, sir, for your fabulous and valuable presentation. On request, now I would like to invite Mr. AKM Tofail Hassan, Additional District and Session Judge, Jhalkati, to share few words with us.
Thank you very much, Anindita, for giving me the chance to utter a few words on this virtual platform. Respected Chair, Honorable District and Session Judge Pirospur, Mohitujaman sir, the beacon of higher judiciary, most luminous and iconic judge of the Appellate Division of Bangladesh, His Lordship Justice Abiman Ali sir, His Lordship Justice Ahmed Sohail sir, Honorable Judge of the High Court Division, my senior colleagues, Honorable District and Session Judge sir, my mates and fellow colleagues, distinguished trainees, Chairman of BIMS, Mr. S.N. Goswami, and the pretty facilitator. I'm sorry, I don't know your designation. Anindita Hasnain. Assalamu alaikum and a very good afternoon. It's indeed a great privilege for us to root our knowledge about the mediation and the role of law in the process of mediation. Our chief trainer, His Lordship Justice Abiman Ali sir, has drawn a pencil sketch about a mediation yesterday, and today he put a multiple color on that sketch. Thank you very much, sir, for your nice clarification. Other trainees are also outstanding in their deliberation. We have filled up our half knowledge into full from this training session. Though it is restless, and despite of having all the challenges and inconvenience in regard to the field of mediation, we have come to know that the mediation process is participative, voluntary, speedy, efficient, economical, informal, conductive, cordial, which preserve the relationship and mutual benefit toward the litigating people. I would like to cast my sincere thanks to BIMS Authority for arranging this amazing training session. Then I want to put our thanks to the Supreme Court Authority and the Ministry of Law and Parliamentary Affairs, Law and Justice Division for their to this program. Then I like to submit our humble gratitude to all the research persons, especially Mr. Abdul Motin Khosru, and I would like to give him congratulations for being elected as the President of the Bangladesh Supreme Court Bar Association. Then Justice Geeta Mittal ma'am, Mr. S.M. Goswami, Tanushree Roy, Priyanka Chakraborty, Justice Korean Joseph, Kevin Brown, Justice Ahmed Sohail sir, Madeline Kimai, Mr. Viragavan, and Jamila A. Ali for their deliberation and sharing their sapiences and sagacity. The time is running out, so I don't want to omit my vote of thanks. Last but not the least, I would like to bestow my gratefulness to all of you for putting your ear on my words patiently. Thank you very much. Allah Hafiz.
Thank you very much, sir, for your wonderful presentation. In this time, I'd like to invite Mr. Muhammad Mohiduzzaman, District and Session Judge of Pirojpur, to deliver the valedictory speech of the 2 days judges training on international mediation for Barishal Division.
The most senior judge of Appellate Division of Bangladesh, the recipient of International Mediation Award and the chief trainer of the training session, His Lordship Mr. Iman Ali, other honorable trainer, Honorable Chief Justice Gita Mittal, Justice Urian Joseph, Justice Ahmed Soel, Mr. S.M. Goswami, Miss Tulsi Roy, Mediline Kimai, Mr. Abdul Motin Kosur MP, Khondogar Muhammad Rafiq Hasnain, and the trainee concerned today and previous day. Assalamu alaikum. It's a privilege for me, a training coordinator, and for the trainees to be a part of this valuable training session on mediation. I must mention my deep sense of appreciation to the speaker of today's sessions and the trainees who passionately listen to our guest. From today's, we got more impressive and great word on international mediation. I find no word apart from the words of speaker on mediation. But I want to mention that mediation is the best mechanism of alternative dispute resolution. To reduce the case backlog in Bangladesh, mediation is one of the important tools. In modern era, mediation is internationally accepted and welcome as alternative dispute resolution mechanism. The result of mediation are very fruitful and sustainable indeed. Mediation is not only reduce the dispute between the parties, it also creates a friendly environment between the parties, which leads to reduce the hostility between the parties. In the formal court of parties are to go through rules of court, but a mediator can make the parties think out of the box. The mediation process is cheaper and of course quicker than the actual process of court. If the judiciary out and out pays to mediation, then we will get a massive output from mediation to resolve dispute. BIMS, Bangladesh International Mediation Society, is one of a self-controlling organization working for the service of people. There may be conflict and dispute among the people for their character, relation, or other so on. BIMS is working to reach the conflict into conclusion. ADR, alternative dispute resolution, is the process of settling dispute without litigation. Mediation is one of the way of ADR. There are wide description of mediation in the section 89A of Civil Procedure Code 1890, 1982, 902. A mediator is must in mediation process. Without a mediator, mediation process is incomplete. A mediator must be neutral and impartial. There should many other qualities of a mediator. The mediator must be experienced in dealing with people in all conditions and under all circumstances. There must be presence of alertness of a mediator. While mediating, he must concentrated with the information provided by the source. He must be alert on both verbal and non-verbal language. That is, what is told and what is lesser than filing the cases. As a result, there is a overload of cases all over Bangladesh, so justice is denied. In respect, mediation process can help us to listen loads of the case. As like Bhutan, by the hard interest of 2 years mediation process, most of the case of apex court are disposed and the lower court are becoming lighter. In Bangladesh, BEAMS is working for this target, and many workshops and seminars are arranging in different parts of the country to create efficient and proficient mediator for further planning. Dear trainees, I hope you are inspired like me by the word of our renowned guest trainer. A big thanks to Honorable Justice Mr. Iman Ali for his efforts towards international mediation and mediation in Bangladesh. I'd like to express my appreciation for Honorable Justice Hita Mittal and Kurian Joseph for their valuable speech on mediation. Further, we are grateful to Mr. N.S. Goswami for delivering his valuable word on source of mediation in Bangladesh. We are very thankful to our trainees, Mr. Tanushree Roy, for his remarkable speech of mediation in globalization world. We also like to thank and express our gratitude to Mr. Medline Himai for his valuable and verbose speech on mediation. Finally, I would like to take this opportunity to place on record our hearty thanks to Bangladesh International Mediation Society for arranging this important training session and for the perfect logistic support and a guideline as it extends to all of us. Dear trainees, I hope you have learned many about mediation, but these things we learned today are the tips of an iceberg. This learning be fruitful where we will apply it. At last, once again, I want to say we are thankful to our chief trainer and other trainers for being with us previous 2 days. Thank you all.
Thank you, sir, for your wonderful presentation. We are almost in the end of today's program. Now again, I'd like to request Honorable Justice Muhammad Iman Ali sir to put a conclusion of the whole 2 day session.
Thank you, Anindita. I have been given 30 minutes to speak, and I think at the end of 2 days, 30 minutes will be too long. So I'm not going to give another speech. I want to first of all congratulate Mr. Abdul Mutin Khosru MP. I can see from the flowers behind him that many have already congratulated him physically. We can only congratulate him virtually. And as Mr. Rafiq said, Gulab Phul, Lal Gulab Shubhecha. So, dhore nen je amra lal gulab diye apnake shubhecha janachhi. Virtually, of course. I want to thank all the participants. They have given up their valuable weekend free time to be here with us. I want to thank all the trainers, respected trainers from home and abroad. You have done a wonderful job in imparting knowledge to our trainees as well as to the rest of us, because I have learned a lot, much more than I expected and much more than I would ever learn without these sessions. And I want to thank Mr. Goswami and BIMS for creating this opportunity for encouraging mediation in Bangladesh, because I do believe that this is what we need to do. I have said on a number of occasions that mediation is the best way for dispute resolution. And with the backlog of cases, I think that is the only way to reduce our backlog. Now, I want to thank particularly Anindita Hasnain for conducting the 2 days with so much patience. And I must say that her father, Mr. Rafiq Hasnain, was very mean last time in giving her a very small token of appreciation. And today he was absolutely mean by not giving her at all any appreciation. So I want to perhaps request Mr. Goswami to arrange a room in Purbani Hotel for Mr. Khandakar Rafiq, because I think he will not be allowed home by his daughter today.